Welcome back to the web extension of our discussion about mental health issues and commitment of people, basically based on the situation with Lonnie Johnson recently in Utah County. And we are going to continue with our panel discussion because we had a lot left to say and I don't think we got it all said. Ron,
Sure.
What point did we miss? We had 10 minutes.
We started talking about the difference between the criminal justice system and the civil commitment system. Adam mentioned that the civil commitment system is not a punishment system. It is based on helping sick people get well. And that can be a misunderstanding where some people are confused. If a defendant is incompetent to stand trial, how can it possibly be that this person cannot be civilly committed? They are separate systems. Sometimes they cross. But it's important for us to remember that they're a separate system. One deals with criminal justice, and can this person be held accountable for violations of criminal statutes? The other is different. It's the same standard that applies to somebody who might be civilly committed, whether they have been accused of a criminal act or not. And so those standards are separate. The aims of the systems are separate, and it's important to keep those two things in mind.
And I think there's an important piece that goes with that, because it's the what happens after you make the finding. So even if someone's civilly committed, and we understand they have to be held in a secure facility at the state hospital for a while, the entire goal really is to move that person to another type of placement that better meets their needs as they become stable, as they get the right treatment they need to progress. I don't think that's what we are all concerned about in the Lonnie Johnson case. I think we're concerned about, certainly I am personally, the idea of keeping him away from the public and protecting the public. That's the opposite of what we're trying to do by getting people back into the community so they can actually get out and live on their own instead of being cared for by the public for years. That's the goal.
In the break between the end of the show and now, the one thing you said, Brad, is I'm counting on you guys to help me sell it. So are you going to have a challenge with this?
I don't know if we will or not. It really depends on different reactions from different groups. And you just really never know where it's going to come from. And so I would rather be well prepared and not need their help at all than go in there thinking that this is some kind of a no-brainer and find out that there's some group that has a major problem with it. It's always better to have your ducks in a row, because in the world of the legislative arena, it's an open meeting. Anybody can come and say anything they want. And it's always nice to have the experts there to say, okay, here's why we drafted it this way, here's what we're trying to do, here's what we're trying to accomplish, and set those parameters so that my colleagues will understand it and be able to have a very informed vote.
I think it's interesting. Last year, the Attorney General's office had a bill that would seem very much pro-prosecution and was prepared pretty well, and it ran into the whole meat grinder of the session and got chopped up pretty well by the end. And I think the more we can do ahead of time to say, look, here are the issues, and here's what we'd like to accomplish, here's the best we think we can do, I think that helps a lot. And that's it seems like we've got a relatively easy road ahead of us until we find out where we really are. So that's
right. My bruises are still healing from that bill, by the way. I was the sponsor of it, so it was an interesting experience, to say the least.
Did you take a lot of flack for that sort of stuff?
You know, that's part of the job. The fact is, if you believe in doing what you got to do, you got to be prepared to take the flack that goes with it.
And we try to minimize that with the approach that we take, getting together working groups with knowledgeable individuals, and then once we have a recommendation, that's not the end of the story. We take that recommendation to all of the stakeholders, everybody who might have comments that they want to provide, everybody who has an opinion on the issue, and work with all of those groups so that by the time we get to the legislative session, we hope to feel certain that we've talked with everybody. And then there are still things that we have not anticipated that come up, but we hope to minimize those.
Okay, so the bill you were talking about last year that hit the meat grinder, so to speak, was that something that CCJJ was involved in?
You'll have to
You're talking about House Bill
was.
150, aren't you? Are you talking about something else? Yeah, that was a bill that came from the Attorney General's office. It was an entirely different experience. And CCJJ was peripherally involved in it, but they were not involved in the vetting of it. It's something that the Attorney General looked at several other states. They looked at federal law, and they crafted a piece of legislation that I thought was a very simple, no-brainer bill, and it turned out that that wasn't the case. So sometimes that happens.
Yeah. We had one of those this year too. So.
Yeah.
Well, gentlemen, anything else to talk about on this?
It's a complicated issue. We keep saying that. We say it because it's true. And I just emphasize it so that we know that when decisions are being made about civil commitment, they're not easy decisions. It's not easy for those who are bringing a petition before the court. It's not easy for the judge who has to make decisions. The judge has to make at least 5 findings in order to civilly commit somebody. We're dealing with civil liberties. We're dealing sometimes with protecting the public. And so what we're trying to do is balance all of those issues to make sure we get it right. And I don't say it's complicated to make it an excuse. I just say that to emphasize that we will be cautious in our approach to make sure that we get the right answer.
You know, and I just have to say, anytime you're taking away an individual's liberty, which is really what we're talking about here, you want to be cautious about doing that. Clearly, in the case of Lonnie Johnson, I'm very happy to take away his liberty. But anytime we craft a statute that has the potential of taking away somebody's freedom, we want those checks and balances in place. We want to make sure that we do it right.
I think the last thing I'd say is it's important for all of us to remember that mental illness or mental defect itself is not a threat to others. It's not the illness that is the danger. It's the way that manifests. And I think what we're talking about in Lonnie Johnson's case is what manifests may or may not be related to his mental illness, but it's certainly something that poses a danger to others, and that's what we need to address.
Very good. Gentlemen, thank you very much. This has been very enlightening. I've enjoyed the conversation. It's been robust and covered a lot of ground. As the bill gets closer, maybe you'll consider coming back and giving us an update.
Keep in touch. Be happy to.
All right. Thank you very much for this extended conversation. Glad you could join us. Remember, County Seat is always on ABC4, 8 o'clock Sunday mornings. We'll see you then.